The difference in a will and a living trust comes twice. It comes first on incapacity, and then it comes again when somebody passes away. And in fact, there really are only two ways to create or build an estate plan. One is on the will and one is on a living trust. The difference when it comes to disability or incapacity planning has to do with how a will itself works. And in fact, a will, as I'm sure you know, is only effective when somebody dies. So will itself does not give anybody any incapacity planning. If you have a will, the incapacity planning you do is something called a durable power of attorney. Durable power of attorney is a legal permission slip that you can give to someone you trust, and basically you say, look, if I'm ever to the point where I can't sign my name, you can sign my name for me. The problem with durable powers of attorney is sometimes they're not honored. In fact, some companies put very, very short artificial expiration dates on powers of attorney because they don't trust them. Maybe they've been changed, maybe they've been revoked. Maybe the person who signed it, in fact, is dead, and when you're dead, the power of attorney is useless. A living trust, on the other hand, is much more permanent and much more powerful than a durable power of attorney, because if you have a living trust, and if the living trust is done right, then the companies, the person that you had to step in to go to the companies where your money is, can demand that they let your helper manage the money. They can't refuse to let them manage the money. Again, with the durable power of attorney, nobody has to honor it. And in fact, in Texas, if they don't honor your durable power of attorney, your helper, your agent can't sue that company, and they all know that. In Texas, if you have a living trust and you're incapacitated, your helper can force the company to take the living trust, and if they don't, they can be sued. And let me tell you, those companies all know that. So a living trust is just a much more powerful way to plan in the event of your incapacity. Trusts and wills differ also when somebody passes away. And interestingly enough, the only two things that trusts are good for is they're really powerful when somebody's incapacitated because we can make them take it, and they're really powerful when somebody dies because you can avoid this thing called probate if you, again, do the trust correctly. Probate is kind of an interesting little thing. Everybody talks about it. Nobody really typically knows what it means. Let me tell you what it means. Probate's a very simple process. Somebody's died, their name is on an asset, we have to go to court and ask the judge to take the deceased name off the asset, put the heir's name on the asset. Now, I said a simple process. It's actually not that simple, but it's, again, a fairly understandable concept. The deceased name comes off the home, the heir's name goes on the home. The deceased name comes off the accounts, the heir's name go on the accounts. At the end of the probate, the deceased name is off all the assets and the heir's name is on all the assets. Sounds pretty simple again. The problem with probate, really there are three problems. One is costs. So probate is almost always going to cost more when somebody dies than have a living trust. Second is delay, and accounts can get frozen, and transactions can get stopped until somebody goes to court at least the first time. The real issue is privacy. And in Texas, all wills become public record. So every time somebody dies, if all they had was a will, their will gets filed at the courthouse and becomes a public record. Anybody, any Tom, Dick, and Harry here or anywhere else in the globe can order up a copy and look at it. That takes some effort, that takes some time, and frankly, most predators, who are what I'm really talking about, aren't that ambitious. But in some counties, and Travis County particularly where Austin is, where our primary office is, doesn't stop at just putting the wills in the courthouse file. They put the wills on the internet. So anybody who dies in Travis County where Austin is, their will is on the internet. And so that makes it much more available to, again, a potential predator, a potential salesperson, a potential anybody to access information that, frankly, most people wouldn't want in the public record, especially if there's a surviving spouse or a surviving child. So if you do a living trust, you can keep everything private. Nothing gets filed at the courthouse if the trust is done well. The reason for that is the way a trust works is, frankly, the deceased name isn't on the house, the trust name's on the house. And the deceased name isn't on the accounts, the trust name's on the account. Well, if the deceased passes away, unfortunately, it happened. But the survivors don't have to go to court and ask the court to take the deceased name off any assets because, frankly, the deceased name isn't on the asset. The trust name's on the asset, and the deceased died, but the trust didn't die. So the new trustee who should be designated in the trust, and if it's not, there's a way to get one, can start managing those assets with the companies that have those assets. Very little downtime, very little problem. But the key is we won't have to file anything at court because we won't have to take the deceased name off of any assets. And because we don't have to take the deceased name off of any assets, and because we're not going to file anything at court, there's nothing for the court to put in the public record. Most importantly, there's nothing for the court to put on the internet about the deceased. So a living trust, where all the assets or the appropriate assets are in the name of the trust, is the way to avoid probate and the way to maintain complete privacy in the affairs of the family.